Hello.
Miss Judge Hatch?
Yes, hello, good afternoon.
Okay, so all you guys heard that?
Yes.
All the attorneys,
Yes, we
excuse
did.
me? Okay. Okay, so we know that the microphones are working and the cameras are working. I just lost my train of thought. It's afternoon. Apologies. Ms. Silverman, could you go on and get us live, please?
Yes, we are live now. Okay.
The Honorable Court of Appeals for the 7th District of Texas is now in session.
Thank you very much. Welcome to the October 7, 2020 afternoon settings of the 7th Court of Appeals. We have one argument or one submission this afternoon, and we appreciate the attorneys in that submission, involved in that submission, agreeing to do their presentation via Zoom as if they had a choice. But soon things will change and we will get that choice again, God willing. We'll go on and call the docket. Normally I give admonishments about how much time you're going to take, et cetera, but since this is the only case, we will forego that. And when we call the docket, I think in the appellant side, there may be 2 attorneys that are going to be arguing. If you could tell us how you intend to split your time, I'd appreciate that. So the case we have before us is 07-20-00093-CV, Western Marketing Inc. versus Western Marketing Inc. and Todd Pitts versus AEG Petroleum LLC. Mr. Houston, I'm assuming you're ready, correct?
Yes, Chief Justice, thank you.
Okay, and Ms. Knapp, I guess you're ready as well for the appellant?
Yes, I'm ready as well, Your Honor.
And how do you propose to divide your time?
Your Honor, we intend to divide our time during our 20-minute presentation equally in half. I'll take the first 10 minutes and Ms. Knapp will take the second 10 minutes. And then I believe I will take the entire 5 minutes of rebuttal.
Okay. And normally I leave it up to the attorneys to enforce that. Do you want me to just click on this and drop you from the Zoom video if you go over your time?
I would say if I go more than 30 seconds over my time, that would be an appropriate remedy.
Mr. Bailiff Ramirez, you know about that? You've heard that? Ms. Silverman, you heard that. Anyway, Ms. Kidwell, I'm assuming you're ready to proceed as well.
Yes, Chief Justice, I am.
And you're the only one arguing?
Yes, I am.
Okay. So with that, Mr. Houston, you take off.
Thank you, Your Honor. May it please the court. AEG's petition alleges that the defendants told a court and told others that AEG was selling counterfeit products. The Texas Citizens Participation Act protects citizens when they give testimony, and it also protects citizens when they share information that has some relevance to a public audience of potential buyers or sellers. Those protections apply here and required AEG to come forward with a prima facie case. It failed to do so. Perhaps the most unique aspect of this case is the extent to which it implicates the right to petition the government. There is extensive litigation in Texas over the scope of the Texas Citizens Participation Act as it involves free speech, and that concerns some of the claims in this case. But the case also involves the right to petition the government.
Let me hijack that, hijack your argument, if I may, or at least intervene. The appellees are basically saying, no, all that was just kind of background information with regard to the Chevron suit and the testimony concerning that. We are really suing based upon the alleged representations made regarding products, et cetera, and the lawsuit and testimony in that doesn't matter. Is of no consequence. What do you say?
I understand that's the position that they're taking in this court. The case law requires the court to first look to the petition to determine the applicability of the statute. And a plain reading of the petition demonstrates that this case arises from, relates to, or is in response to the Chevron lawsuit and Mr. Pitts's declaration given in connection with that lawsuit. We've detailed that in our briefing, and it would take almost my entire 10 minutes to give every single example. But in paragraphs 17 through 23 of their original petition, they describe the Chevron lawsuit in some detail. They describe it as part of the defendant's scheme. They say that that scheme included ginning up the Chevron lawsuit out of whole cloth. They describe in detail.
Well, let me ask you this. Are you suggesting then that the Chevron lawsuits, what the buzzword, inextricably intertwined in all their causes of action?
I don't know that it's inexplicably, well, I do think it is inextricably intertwined in all of their causes of action. Yes, Your Honor, because it is expressly incorporated by reference into all of their causes of action.
Okay. And you think that includes the Antitrust Lanham Act causes of action as well?
I do. And even Wade Alexander, who is from AEG, and his affidavit in response to the motion to dismiss, when he was describing the false statements, included the statements made in the Chevron lawsuit. And so their own proof submitted in response to the motion includes testimony from their own witness identifying statements made in the Chevron lawsuit as false. It's not just the petition, although I think a plain reading of the petition is enough. In addition to the petition, when we filed the motion and they sought discovery to support the motion, or support their response to the motion, they asked the court to allow them to depose Mr. Pitts on the truthfulness of the statements in the Chevron declaration, demonstrating that before they filed their response to the motion, they certainly believed that they were going to need a prima facie case on that issue. And as I said, some of the evidence that they attached in response specifically identifies the Chevron lawsuit. I would argue by analogy that if you can imagine a world in which this case got to trial and they began to put on proof of the Chevron lawsuit, and I stood up and objected to the trial court judge that I had no notice that they intended to hold us liable based on the Chevron lawsuit, that objection would be overruled in a heartbeat. The petition is absolutely clear that they are alleging wrongdoing based on the Chevron lawsuit, including identifying it as more harmful. They specifically say that it is more harmful than the other alleged false statements. Even more damaging is their word in paragraph 20 of their original petition. And in addition to that, they specifically identify damages arising from the Chevron lawsuit, which is not something you would do if you were just giving background information. They allege harm and specifically identify what they characterize as hundreds of thousands of dollars in legal fees as harm arising from the Chevron lawsuit and its declaration.
This dispute had been going on for some time before the filing of the Chevron suit, right? And they were, AEG was on notice of what they alleged to be Pitt's inappropriate behavior. And so, and it was filed, this suit was filed, what, within about a week almost of the filing of the Chevron suit? Or am I off?
I think you're off. It was more a few months. They had the Chevron lawsuit had been filed. They were starting the process of discovery. They had actually reached out to me requesting to take Mr. Pitts's deposition, and then before taking the deposition, served him with this lawsuit, which is one of the concerns that we have, that the filing of this lawsuit and the lead up to a deposition gets right to the public policy behind the Texas Citizens Participation Act. As the court said in Lipsky, the Texas Supreme Court said in Lipsky, the act is intended to prevent retaliatory lawsuits meant to intimidate or silence. And suing somebody and his employer shortly before he gives a deposition is a clear shot across the bow that if he says something they don't like, they will continue to pursue his employer in retaliation for it, which gets, again, right to the heart of the public policy behind the act. This case, of course, is not just about the right to petition the government. It also includes statements that were made outside of the judicial context, statements made to other suppliers and other participants in the market. This too is an area where I think this case does not run into the same problems that many of the Texas Citizens Participation Act cases run into. This is not a private contract dispute where we're seeking to invoke the act to protect ourselves. As Wade Alexander from AEG testified repeatedly in his affidavit in response to the motion, he says there was no contract between AEG and Western Marketing, and no contract between AEG and Chevron. This is not a private contract dispute. It is an example of somebody communicating to other participants in the market that there is a serious issue with regard to products in the marketplace. And that's certainly something that a reasonable buyer or even reseller of a product in the marketplace would want to know. In the Creative Oil case, for example, the Texas Supreme Court said the communications in that case weren't enough because the only issue was whether a lease had been terminated or not and who should get paid for the oil. It wasn't about the quality of the oil. Here, the communications go directly to the quality of the product that is being sold. And that ties it back into being a matter of public concern, as that term is used in the statute, and being a communication about a good product or service in the marketplace, as those terms are used in the statute. As the court explained in the Lipsky case, the standard for whether a communication about a product or service in the marketplace arises to a matter of public concern is whether the information has relevance to a public audience of potential buyers or sellers. And certainly I would think that the idea that somebody is selling a product as a counterfeit good goes directly to something that would be important to a public audience of potential buyers or sellers. The closest analogy here is that somebody has bought a generic product and is reselling it as a brand name product. I could go to Walgreens and buy generic Tylenol and resell it as brand name Tylenol. As we all know from the drugstore, that brand name Tylenol costs more, and people who are buying what they believe to be brand name Tylenol want to know that they're getting brand name Tylenol, and that is why this was an issue of public concern in the marketplace. I'll yield the rest of the time to Ms. Knapp.
May it please the court and Ms. Kidwell. Mr. Houston, I think, has eloquently addressed why the Texas Citizens Participation Act applies to the claims brought in this lawsuit, and I will address the failure of AEG to put forth their prima facie case. The Texas Supreme Court has made clear that the clear and specific evidence required under the TCPA is evidence that must be unambiguous, sure, free from doubt, and explicit. And this court has recently articulated in the Mesquite Services case, the evidence should be unaided by inference or presumption.
Is the evidence otherwise competent or admissible?
No, Your Honor, we don't believe that all of it is. We've watched.
No. The type of evidence needed to satisfy it, does it have to be the type of evidence that would be admissible at trial?
I do believe it should be admissible evidence, Your Honor, yes. And
I knew there were some objections made as to some of the evidence. Another question, I think there's some indication in the appellee's brief when they were talking about the evidence to support the elements, they alluded to pleadings. And they said, look at the pleadings that can provide specific and clear evidence. And maybe I'm reading that wrong, but are pleadings evidence for for purposes of the anti-SLAPP proceeding?
So under the TCPA, the court can look to pleadings. The courts say, though, that that is a gamble to rely on pleadings, and the conclusory type of allegations that are included in pleadings, like the defendant's bad actions caused me harm, are not evidence that's clear and specific, because that type of evidence.
So you can have a pleading that is 100 pages long and reads like a novel and has every detail in it, and it's just a pleading, and that would satisfy the requirements to prove every element as long as they had sufficient detail with regard to every element and it was just in the pleadings.
Ostensibly, that may be the case. I don't think there's a case in Texas in which a court has held the pleadings alone to be sufficient.
One of the reasons I ask is that in summary, they've likened this procedure to something like summary judgment. Have they not?
In a way, it is different than summary judgment. The statute also allows you to look at supporting and opposing affidavits. Unlike in a summary judgment, that standard's a little bit different. You also can look at the evidence that you can consider under the summary judgment rules, and that's also expressly said.
I understand that, but in summary judgment, pleadings aren't evidence.
That's correct. That's correct. But regardless of what the document is, it still needs to be evidence that is clear and specific and does not delve into inference and ambiguities. And the evidence in this case does just that and is not enough to prove the prima facie case. For example, in the antitrust and also in the conspiracy claims, those claims require evidence of a contract agreement, a combination, a conspiracy between two people to agree to do something. And there's no such evidence in this case. Here, they've looked to some sort of an alleged agreement between Lubriformance and the appellants. It's really not clear from the evidence at all that there even were discussions between those two entities in the time frame that they're looking at. Their basis of the claim as well, the guy at Lubriformance said he was interested in doing business with us and then later changed his mind. But that's riddled with speculation as to why he changed his mind. It's equally likely, and in fact, more likely, that he changed his mind for the reason that he said he changed his mind, which is the behavior of AEG itself and had nothing to do with the appellants. And that's certainly not enough to...
What behavior of AEG?
He said he didn't like the way that Mr. Alexander and Mr. Gomez were behaving. He thought they were just trying to drum up something bad about Western marketing, as I believe what he said. He didn't get a good feeling from them, is what I recall him stating in his deposition on written question answers. But he also categorically denied that anything that Mr. Pitts said influenced his decision to not do business with AEG.
But do you have to rely on that? I guess that's another thing about the TCPA. Do we look at the evidence in the light most favorable to the non-movement?
And so while the court needs to look, the court should look at all the evidence, we believe. And that's clear in the TCPA that says you can look at supporting and opposing evidence. I think that's important in order for them to meet their burden to show with clear and unambiguous evidence their prima facie case. But even if you ignore what the Mr. Brand at Lubriformance said was his reason, you're left with nothing but coincidental timing, which the courts have said is not enough. I'm sorry, did I interrupt you, Chief Justice Quinn?
I was wetting my whistle, excuse me.
Okay. And I'll move on to the remainder of the claims and try to address them quickly in my remaining time. They fail for many of the same reasons. The Lanham Act claim, the tortious interference claims, the business disparagement claims all fail because there's not sufficient prima facie case of causation or damages, which all those claims require. With respect to SJB, the evidence is that, well, they haven't purchased from AEG in over a year since allegedly Mr. Pitts made some comments. But that's not evidence that they would have purchased from AEG, or that anything that Mr. Pitts said or did had any influence over them. They just as well could have not needed to buy the product, or like Mr. Brand at Lubriformance just decided they didn't get a good feeling from AEG. There could have been any number of reasons why they didn't purchase from AEG. The fact that they didn't is not proof of causation. Similarly, on the Old World and Lubriformance, which are at issue, at least on the tortious interference claims, I believe, there is only a statement of a number of how much AEG thinks it was harmed. There's no showing of how that number was calculated. It's just like the cases we've cited in our brief where the defendant says, I think I'm harmed at least $500,000 or at least $1 million. Now, maybe AEG's number is not as round of a number. I think one of those is 67,000, the other is 580,000. So maybe they're not as round of numbers as those, but that's still just picking a number out of the air and saying, this is how much I think I was harmed, without stating the reason and the calculation behind that. And that's not enough to show the prima facie case of damages under the TCPA. And with respect to the defamation and the business disparagement claims, first, there's evidence in the record that the statements made about the counterfeit product were actually true. AEG's evidence establishes that they were sold, in Mr. Houston's words, a generic product and then resold it as a name brand product. And that's exactly what they were doing. And so Mr. Pitts going around telling people that they were selling something as what it was.
Is that with regard to is that with regard to the bulk oil?
That was with respect, he made it, I think the allegations are Mr. Pitts made comments that AEG had sold generic or had sold counterfeit product. It wasn't, he isn't alleged to refer to any specific product, but we know from AEG's evidence where they have attached invoices from what they got versus what they sold, that it was actually the generic and then they resold it as a specific. And we also know that from Chevron's interrogatory answers, which AEG included in the lawsuit, and Chevron also swore that that's what had happened. And so my time is up. I will give it back to the court.
Thank you, counsel. Any questions? Ms. Kidwell.
Thank you, Chief Justice, and may it please the court. My main response to all the arguments that I've just heard is that most of them don't need to be considered. I believe the appellants actually have the cart before the horse, and that the analysis in this case ends not only on the first step of the TCPA, zigzagging burden of proof process, but it actually ends on the very first part of the first step. So in my limited time today, I'd like to focus on 3 issues and of course answer any questions that the court has. The first has to do with the defendant's failure to meet their very initial burden. It's essentially a fundamental flaw in the way their motion to dismiss is constructed. And I think that provides the simplest way for the court to resolve all of the issues that are presented in this appeal.
Often I found that the simplest way ends up to be the hardest way.
Well, Chief Justice Quinn, you may be pleasantly surprised in this instance. So I would like to talk you through that. I would also like to address defendant's theory that this case is based on the Pitts declaration. I don't think that theory can be reconciled with the pleadings or the evidence in this case. And I think that in effect, it invites this court to disregard the standard of review that it needs to be applying during the first step. And then third, to the extent that there's time left, I would like to address their arguments about free speech. Those really get to a fundamental problem where there are different types of communications alleged in AEG's pleadings. Some of them are potentially protected, some of them are clearly not. And there are yet other claims that are based on things that aren't even communications at all. And so the free speech thing sort of falls apart. But that actually brings me back to my first point, which is the defendant's failure to meet their initial burden. As the court knows, the defendants have the initial burden in a TCPA case to show that each of AEG's 6 claims arise from some sort of TCPA protected communication. Now, in this case, if you look at the defendant's motion, you'll see that they made no attempt to do that. Instead, what they did, as they're doing here today, is they relied on blanket assertions that the entire case was filed in response to the Pitts Declaration. And they also took a theory that the case was based on statements about AEG's products and that implicates protected speech. Now, there are 2 big problems. First is global assertions about a lawsuit as a whole are insufficient to meet a defendant's initial burden under the TCPA. A defendant can't just come in and say, this case is the TCPA applies, they didn't have evidence of their prima facie case dismissed. The statute, and I'm specifically looking at 27.006A under the governing version, which is the slightly prior version of the statute, it requires the court to consider pleadings and evidence, quote, stating the facts on which the liability or defense is based. Okay, so it doesn't say, court, look at the facts on which the whole lawsuit is based. It wants you to look at individual claims.
Let's look at your antitrust. I think one of the arguments with regard to your antitrust is that it's not really based on any type of statement as opposed to an agreement. And you're indicating that, agreement, yeah, though it has words, it's not that type of statement. Let's assume that's correct. If a portion, there also have to be some type of, and this is my word, chilling effect on competition, et cetera, et cetera. If a portion of proof with regard to that chilling effect is we've got an agreement and here's the proof of it, they're going out and they're telling people this and saying because of this stuff, you should not buy with them, just buy with us, et cetera, et cetera. And also one of those things that you're relying on happened in the Chevron lawsuit. It was a statement uttered only in the Chevron lawsuit. You have that, but then you have things that are totally separate from the Chevron lawsuit that you're basing it on. That you mentioned the Chevron lawsuit statement, is that enough to bring everything in, or do we have to look at the bulk of the other statements unrelated to the Chevron lawsuit to determine whether or not there's a communication involved that's within the TCPA?
Your Honor, I think that gets right to my second point, and that is that the cases all say you've got to look claim by claim, communication by communication. So it is not enough for them just to say this lawsuit is based on a statement made in Chevron. It's not enough for them to say this lawsuit is based on statements about AEG's products.
How about if they say this lawsuit is based a little bit upon what was said in Chevron, a little bit what was said to the Lubriform, a little bit what was said to SJB, a little bit what was said to this other person. Is that enough to capture it all?
No, Your Honor, because again, they're the moving party. They have to come in their motion and they need to explain why each claim involves a protected speech. These sort of global assertions, and I'll point you to 2 cases that maybe will help me answer the question. The Grist case out of Dallas makes it clear that each cause of action has got to stand or fall on its own merit. So if the defendants had done sort of what you're hinting at, if they had come in and said, okay, let's look at the defamation claim. And then if they had said, well, this defamation claim is based on the statements about AEG's products, that's a matter of public concern, so that claim needs to be dismissed. Then they could take the next claim. And if they had gone through and actually—
How about they go to defamation, take your example, and they say it's based on what they said about the products, And we can prove that by looking at what they said in the deposition or during the trial of the Chevron suit. It indirectly implicates the judicial proceeding, and I guess this is just an example, hypothetical. It implicates the judicial proceeding. Is that enough to get that claim when they're using both statements inside and outside the judicial proceeding?
No, Your Honor, I don't believe it is. I mean, I think the Texas courts are very consistent in requiring a claim by claim analysis. They are requiring, not allowing wholesale dismissal of entire cases based on sort of global sorts of arguments. I mean, honestly, the White Nile software case that I provided a supplemental citation of authority to, I mean, that case doesn't say anything fundamentally new, but I think it sort of wraps the issues up very nicely as far as it relates to this case. And basically says, look, when the pleadings, the evidence, and the arguments are based on a mix of protected and unprotected activity, and the defendant doesn't distinguish between the two and essentially explain why for each claim there's protected activity involved, the motion to dismiss under the TCPA, quote, should be denied. That's looking at the trial court's perspective, and that's exactly what the trial court did here. From the Court of Appeals perspective, what the White Nile Dallas Court of Appeals said was, look, a court of appeals can just say that if the defendant's motion does not actually go through and address things claim by claim, communication by communication, that by itself is a sufficient basis to affirm an order denying the motion to dismiss.
So if the evidence, clarify that for me, I think you may have just answered a question in my mind. If the evidence they're using has protected speech, if you will, protected communications encompassed by TCPA and non-protected, then that's enough to say TCPA doesn't apply?
That's enough to say that the defendants didn't meet their initial burden to show that the TCPA does apply. And
they have
again,
to show that every communication is within TCPA.
They have to show each and every claim is within the TCPA.
Not claim, communication. Because a claim can be based on different communications, and multiple communications, can it not?
No, absolutely, absolutely. And
you have to show that each communication is within TCPA, not claim, communication.
Yes, I'm going to partially agree and partially disagree, if I may. I mean, the cases do talk about having a claim by claim analysis, but they also talk about analyzing each communication. And I think where we're going to come together, Chief Justice Quinn, is that in this case, we actually have several types of communications. We have statements about AEG's products. Okay, those are potentially protected for the reasons that the appellants have said. But we also just have statements about AEG. Statements that AEG is, not trustworthy. Statements that AEG is bad news. Those sorts of statements aren't protected statements. So we have different types of statements. And then we also have allegations involving essentially agreements to enter into illegal boycotts. Okay, those are agreements. Those aren't even protected communications at all. So again, sort of by relying on a fatally flawed motion, the defendants didn't give the trial. I mean, the trial court actually worked really hard and went claim by claim, but the defendants did not actually do what they were required to do in their motion to get off of step one. And so, I mean, I would really encourage the court to have a look at that White Nile software case, because I do think it gives a nice blueprint for what's fundamentally wrong with the motion to dismiss in this case, and why it would be, that's really the most direct path to affirm what the trial court did. I really think it's the simplest reason. Going on to the Pitts Declaration, I think the other side's arguments are wrong, both on the law and on the facts. Again, this is another good example where I think that the motion suffers from the flaw we just talked about. Globally saying that the entire lawsuit is based on the Pitts Declaration, it doesn't show that the Pitts Declaration was legally or factually necessary to support any particular claim. And the trial court really picked up on that. And I think that was why the trial court sort of saw through the Pitts Declaration argument. Another problem with the argument on the law is that essentially the defendants are saying, look at the timing of this. AEG filed this lawsuit as retaliation for the Pitts Declaration. Well, that's their spin on what motivated us to file the lawsuit. But under the standard of review, the court should be looking at the pleadings and the evidence in our favor, should be trying to construe the pleadings and the evidence in favor of the conclusion that they don't implicate protected speech. And again, this brings us, I think, to the facts of the matter. I look at this both ways. I can look at it chronologically and sort of looking through, what happened. Well, the parties did business for a while. 2017, things start falling apart. By spring of 2018, we've got Pitts going around making disparaging statements. We've got potential illegal boycott agreements. There's a lot of underlying conduct. Then we eventually get to the Chevron suit because Pitts has been making the same sorts of comments to Chevron. And in the context of that suit, Pitts gives his declaration. Well, what the other side wants you to believe is that the only thing Pitts did that's relevant to this lawsuit is that he gave the declaration in Chevron. Well, that's not true at all. AEG's claims are based on all of the conduct in 2017 and in early 2018 that led up to the Chevron lawsuit, that led up to the Pitts declaration. And it's that underlying conduct that provides the basis of the claims, not the Pitts declaration. And I would also suggest that the mere fact that Pitts gave a declaration in another lawsuit does not immunize him from liability from the claims asserted by AEG in this lawsuit. And that's essentially what they're trying to do with this Pitts declaration. Again, there are lots of cases on this, and I know the parties have cited a lot of cases, but the one that in preparing for argument I felt was the most helpful was the Beving versus Beatles case. It's cited in our brief, and I think it just kind of goes through a good analysis, similar kind of case where somebody had given a declaration and a deposition, and the Court of Appeals recognized that, wait a minute, just because somebody gave a declaration doesn't mean that all the claims are based on that. So, again, I think the trial court analyzed that issue correctly and recognized that the claims are based on the underlying conduct. Whether or not Pitts made his declaration, that doesn't, we didn't sue Pitts because he signed a piece of paper. We sued Pitts for what he did and WMI for what they did in the period leading up to when we filed the lawsuit. With respect to protected speech, this argument, ultimately goes back to what I say is the fundamental problem with the defendant's motion. And that is that because they didn't go claim by claim, communication by communication, they didn't account for the fact that AEG's claims are really based on two distinct sets of allegations. And Chief Justice Quinn, I think you've already been getting at this with the antitrust and civil conspiracy claims. Those claims aren't based on the fact that Pitts was going out making statements about AEG and its products. Those claims were based on alleged illegal boycott agreements that were formed between the defendants and between some other product distributors, okay? There were agreements basically to drive AEG out of business. There's no protected speech involved in those sorts of agreements. Now the defendants sort of say, well, those agreements are based on the same communications that underpin the rest of the claims. No, the only communications that would underpin those agreements would be the very kind of private business communications between a handful of private parties, basically Pitts and a couple of other parties mentioned in the pleadings. And they're not things about the quality of AEG's products. They're just, hey, let's get together. Let's not do business with AEG. Let's drive them out of this market so we can all start charging higher prices. That's the basis of those allegations. And there's nothing protected about that. And there's no case in Texas that says that sort of thing is protected. The defendants try to sort of get around this by saying, well, there's no evidence of any contracts. But remember, if we're still on step one, we're trying to figure out whether they have met their initial burden to show that the TCPA applies. This isn't the time to be putting any burden on us to be coming forward with evidence. We've alleged that there were illegal boycott agreements, and for purposes of step one, the court accepts that and construes everything in our favor. So I would say, that's one set of claims. The antitrust and civil conspiracy claims, they're not based on protected communications. And the trial court recognized that and refused to dismiss those claims for that very reason. With respect to the remaining claims, These are based in part, and actually, Chief Justice Quinn, I'm getting back to your question. Maybe I'll answer it in my remaining time, maybe not. But it gets back to the point that these claims are based in part on communications about AEG's products, but they're also based on communications about AEG. You know, sort of the statements about AEG's business reputation, statements about Wade Alexander, who is AEG's president and CEO, you know, his bad news, things like that. So there are a mix of communications. Again, think back to White Nile. If there are a mix of communications, it was up to the defendants to explain how this all plays out, and they didn't. Second thing is, if we just say, well, okay, even though these 4 remaining claims are based on a mix of communications, some of them are protected, some of them aren't, even though the defendants didn't really explain, we're just going to go ahead and lump everything together and assume that these are potentially protected. Here's where we get to the commercial speech exemption. And the trial court, this was another basis for the trial court's order denying the motion to dismiss. Basically said that, you know, to the extent that any of the claims are based on statements about AEG's products, and those could be potentially protected, those fall within the commercial speech exemption. Now, there's been a fair amount of writing on it. I think this much the parties agree on, and that is that, you know, this is a statutory exemption. It has been construed by the Texas Supreme Court in Castleman, and Castleman has imposed 4 requirements. But at the end of the day, there are actually a lot of cases.
2 of those judges on this panel kind of messed up in Castleman.
Well, you know,
And I won't point fingers.
Okay, I understand that, and I am not entirely, I feel like Castleman may be a little difficult to completely reconcile with the statute, but we have the Supreme Court's opinion. We accept it as the law of Texas, and it is what it is. 3 points about it. First, you don't even have to get to the commercial speech exemption, because unless the defendants properly met their initial burden, the burden never shifted to us to show that this exemption applied. Secondly, the defendants are actually trying to construe Castleman even more narrowly than the Castleman court construed the statute. And so what the defendants are saying, or the appellants are saying, is that Castleman requires that the statements have to be about the defendant's particular products. So in the defendant's view, the commercial speech exemption only applies if the defendants make statements about the defendant's products to the defendant's own customers. And I would just say, A, that's not what Castleman says, and B, that doesn't make any sense, because if that's all that's happening, the plaintiff hasn't been injured, the plaintiff's not even involved in this transaction. So the reality is the statements just have to be about the kind of products the defendant sells. In this particular instance, what distinguishes this case from Castleman, and I think is really sort of the key point in the analysis, is that both AEG and WMI are engaged in the same industry. They are competitors for some of the same customers. And so in this instance, statements made to, you know, one potential customer is the equivalent of a statement made to another potential customer. A lot of the distinctions that you get from Castleman, frankly, don't matter. Bottom line is, because they're competitors in the same industry, because the pleadings and the evidence suggest that the statements were made to actual or potential customers of both parties, and because the statements were made to advance WMI's own business interests, I think that this is clearly a case where if the court gets that far, it would do what the trial court did and say, you know what, the rest of the claims, to the extent they're based on statements about products, the commercial speech exemption applies. And I've exceeded my time, so thank you very much and for your attention, Your Honors.
Do the other judges have any questions? Thank you.
Thank you.
Rebuttal, Mr. Houston.
Thank you, Chief Justice. I think the best response to the arguments that Ms. Kidwell has made is to take a close look at the petition in the lawsuit, the motion to dismiss that we filed, and the supplement to the motion to dismiss that we filed after they amended their petition. As the Texas courts have noted, it would be impossible to determine the basis of a legal action and thus the applicability of the Texas Citizens Participation Act without considering the plaintiff's petition. Looking at the plaintiff's petition, all of the distinctions that Ms. Kidwell is trying to make now about what the basis for the claims are are not present in the petition. The petition incorporates by reference all of the facts, including the allegations regarding the Chevron lawsuit and the separate allegations regarding Mr. Pitts' exercise of his right to free speech. That's one issue. The other issue is she claims that we didn't take this up on a communication by communication basis in our motion itself. And that is incorrect. If the court looks at the motion to dismiss that we filed in the trial court on pages 12, 13, and 14 of that motion, we specifically divide the bases for the lawsuit up into a bucket of these are the things that were protected by the right to free speech, which is the alleged statements to SJB and Lubriformants and Old World Industries and others. And these are the things that are protected by the right to petition. Those individual communications by communications are absolutely identified in the motion itself.
Let me ask you just to clarify, communication by communication. Let's assume we have one cause of action, not multiple. One cause of action. It is the evidence underlying it involves communications that are protected and are not protected. The ones that are protected, does that capture everything, or do you really have to say, no, you can't base that claim on the non-protected, you can only base it on the protected ones?
I think that both the plaintiff and the defendant have to deal with it on a communication by communication basis. It's never been our position that the alleged statements to SJB should be dismissed because of what we said about the Chevron lawsuit. That is not our position now, and that was not our position in the trial court. That's consistent with this court's holding in Mesquite Services, by the way. You analyzed a breach of contract cause of action and found that one of the theories of recovery for breach of contract, the covenant not to solicit, was protected, and the covenant not to compete was not protected, and you dismissed one and not the other. Also in the Toth case, the court recognizes the need to go communication by communication and dismiss the ones that are protected, not dismiss the ones that aren't protected. That's not something the trial court did here. She ruled in the entirety. I do believe that the Chevron related claims should have been dismissed because of the right to petition the government, and the claims that are related to the statements made to others should have been dismissed because of the right of free speech. That's how our motion was written. I would also like to draw the court's attention to the supplement to the motion that we filed, that they amended their lawsuit, and we filed the supplemental to our motion on pages 3, 4, and 5 of that motion. We again go through in detail communication by communication. These are, Ms. Kidwell characterized us as making broad conclusory statements that the whole lawsuit is based on the Chevron lawsuit. That's not consistent with the record in this case, Your Honors. The record in this case shows that at the trial court level, we identified the right to free speech as one issue, the right to petition as the other issue. I believe this court should address those issues separately, and the trial court should address those issues separately, but both require dismissal. Finally, with regard to the commercial speech exception, this is briefed extensively in the papers, but these statements were not statements that were made when Western Marketing or Mr. Pitts were trying to sell product to anybody, and there's no evidence to support that in the record. So I appreciate the court's time today and thoughtful consideration of the case. Thank you.
Let me ask you a question before the time actually does run out. Well, it's run out, but I'll ask anyway. If we were to assume that, for instance, the antitrust claims involved non-protected speech, so they survive. To the extent they are based upon an agreement with SJB and Lubra or whatever, that seems to be the same basis underlying the same agreement underlying conspiracy claims. Let's say the defamation and those things are protected speech. They've got to prove those elements. and they're using conspiracy and tying it to the defamation. Well, if there's no evidence of an agreement and we say no conspiracy, what do we do about the antitrust? Can we not say anything because that was outside the TCPA?
Well, Your Honor, I feel very strongly that the theory of recovery on the antitrust is not outside the TCPA. Although public,
No, just assume it was.
okay. If you assume that the antitrust claim is outside the TCPA, then obviously the antitrust claim survives.
Okay, but even though a potential element may have been negated by the failure to prove a conspiracy in relation to those claims that involve protected speech within the TCPA.
I do believe that that would be the consequence of the TCPA not applying. If it doesn't apply, that's the end of the inquiry. We move for summary judgment when we get back to the trial court, but that's the right legal effect.
Okay. Any questions? Thank you very much, counsel, for agreeing to present your cases this way. We look forward to talking with you in the future in other cases in person. The case is submitted and you are excused to go, and we will be in recess until a later date. Again, thank you very much.
Thank you, Your Honor.